all please be seated? Welcome to the 14th Court of Appeals. All right, first on the docket is 1424-00622 CV. Appellants ready?
Appellants are ready, Your Honor.
All right, are you going to reserve any time for rebuttal?
5 minutes.
5 minutes. Appellee, are you ready?
Ready, Your Honor.
All right, approach the lectern and let's get started.
May it please the Court, the denial of Odyssey Phoenix's special appearance should be reversed for 2 reasons. First, Carlton fell far short of the minimum contacts necessary to establish personal jurisdiction over him in Texas. And second, even considering, as Carlton attempted, other contacts by other entities, Carlton did not plead or prove the necessary showing in the stringent test to impute some other entity's foreign contacts to Odyssey Phoenix. First, Odyssey Phoenix factually rebutted the threadbare jurisdictional allegations in Carlton's petition. The petition simply alleged that all the Odyssey defendants did substantial business in Texas. Odyssey Phoenix filed with its special appearance the Danton affidavit, and there's additional evidence in the record showing, in fact, Odyssey Phoenix LLC does not do substantial business in Texas. In fact, Odyssey Phoenix is not registered to do business here. It has no offices or employees here, no location here, and was not involved in the acts alleged at sea. In fact, it has no registration here because it's a Delaware company whose primary place of business is in Louisiana. So
they did own the vessel, though.
I beg your pardon?
They own the vessel.
That is correct. Odyssey Phoenix LLC is the owner of marine vessel Odyssey Phoenix. That is correct. And that is undisputed.
The record's not very clear, and we don't know exactly how the injury occurred. I mean, was it while the 2 vessels were parked, for lack of a better word, next to each other, and Carlton went on the ENSCO boat? And I mean, do you have any information as to how the accident occurred?
I'm afraid all that this record discloses, Your Honor, are allegations, which shed some light, but they are merely allegations from the petition. And then there's some tangential testimony about those circumstances in the Danton deposition, which is in the record. And putting those 2 together, at least it is alleged that there were 2 vessels at sea outside Texas coastal waters. The Valeris Resolute, I think, was the ENSCO vessel, and then there was the Odyssey Phoenix there to provide resupply. And because the merits have not been litigated, it's not clear, but the allegation, I believe, is that Mr. Carlton was injured when an ENSCO employee operating some large piece of heavy equipment struck him, apparently, and caused injury. At least that's the allegation. But yes, Odyssey Phoenix LLC, the appellant here, was the owner of the vessel. It did not have any contact with the state of Texas. It is a Louisiana-based company incorporated or organized under the laws of Delaware. So,
well, talk to us about what kind of control would be required to impute contacts from one to the other.
Well, Your Honor, because imputation of contacts is the only path that Carlton really attempted to travel to obtain jurisdiction over Odyssey Phoenix, he is faced with a stringent test. And the Texas Supreme Court's PHC Minden versus Kimberly Clark case does a great job laying out that stringent test. There are 2 reasons that Carlton did not begin to make that showing on this record. One is purely factual, one is partially legal. If I may start with the factual. To impute a parent company's contacts to a subsidiary or to establish an alter ego showing, of course there must first be a parent-subsidiary corporate relationship. Carlton didn't even make it that far.
Well, that's actually one of the things I had planned to ask you about, because in the Amniel case from this court, we said in determining whether to treat the 2 companies as one for jurisdictional purposes, and then it lists the elements, but it doesn't, 2 companies as one, it doesn't say parent subsidiary, and here we have 2 subsidiaries, right?
Well, you essentially have, I would call them corporate siblings. You have Odyssey Marine, the entity whose contacts Carlton relies on, and Odyssey Phoenix. And both of those, as far as the record discloses, which is not much, are wholly owned by Odyssey Marine Holdings,
Right, are there cases where they talk about one subsidiary to the other, or one sister, as you say?
I will say, Your Honor, that I'm not aware of either side's briefing having cited a case that deals with corporate sibling jurisdictional veil piercing. I don't think anyone cited a case. I don't recall reading a case that deals with that scenario, but.
So you're thinking it's just parent to subsidiary for alter ego or veil piercing?
Well, and it's because control and ownership of one entity by another is practically always a matter of being higher up in the corporate hierarchy. I'm not aware of a case that's talked about piercing the corporate veil to go sideways instead of up, as it were. Or sometimes you can have it in reverse from parent to subsidiary. But this court's opinion in Amneal Pharmaceutical, as Your Honor mentioned, emphasized, as the Supreme Court did in PHC Minden, that above all other factors, in fact, what this court said was the most important factor in any jurisdictional veil piercing or alter ego analysis is a showing that whichever entity's contacts you wish to use to impute, that entity must have actually exercised some abnormal or atypical control over the, I'll call them the subsidiaries' internal affairs and business operations. And the courts, including this court in Amneal, have emphasized this is far beyond the mere expectation of common ownership, shared directors or officers among companies, shared headquarters space among companies. The Supreme Court discussed this in the PHC Minden case, and several of these factors are also discussed in this court's opinion in Amneal. And those aren't enough. Those sorts of factors can make control possible. But as this court emphasized, calling it the most important factor, there must be a showing that the, I'll call them the parent entity, must have actually exercised unusual levels of direct control. This record contains zero evidence suggesting that specifically Odyssey Marine, the entity that had a contract with the Texas non-party Anadarko, exercised any level of control over the internal affairs of Odyssey Phoenix, let alone a showing that that particular entity, corporate sibling as it were, exercised some abnormal, unusual level of control. There is no witness in this record, there is no document in this record that establishes any sort of unusual or even, frankly, normal level of control over Odyssey Phoenix by some other entity. The Texas franchise tax records, which Mr. Carlton introduced into the record, established merely, as I mentioned earlier, that Odyssey Phoenix is 100% owned by Odyssey Marine Holdings. Odyssey Marine Holdings, for all that this record discloses, does not have the Texas contacts that Mr. Carlton so greatly wishes to use. That's Odyssey Marine. As I have said, there is simply nothing in this record that would allow a court to impute the foreign contacts of Odyssey Marine to Odyssey Phoenix.
So what if the same person is controlling both?
Well, Your Honor, as I mentioned, if I understand your question, the courts in articulating jurisdictional veil piercing, which they say is harder to accomplish than liability veil piercing, account for and expect that there will be in the corporate family common or shared officers. For example, Mr. Danton here, as he testified in his deposition, is the CEO and president of multiple Odyssey entities, including, as he said kind of incidentally, Odyssey Phoenix and Odyssey Marine, among others. But the case law on piercing the corporate veil has been very clear. That is not enough. You would expect in a corporate familial relationship, parent, subsidiary, call it what you will, that there will be some level of, for example, stock ownership, perhaps 100% stock ownership. There will be oversight by a parent. There will be articulation of policy, checking on financial performance. These are normal incidents of a corporate relationship or a parent-subsidiary relationship. And this court and the Texas Supreme Court have been emphatic. That is not enough.
So was the plaintiff required to plead what kind of, or what doctrine was justifying imputing contacts?
Well,
go ahead.
Yes, Your Honor. In a word, it is, as again the Texas Supreme Court said in PHC Minden, and this court said in Amneal and other cases we cited, it is always the burden of the party attempting to pierce the veil to plead and prove it. Here, Mr. Carlton did not plead it in his petition. He waited to raise this idea in his response to Odyssey Phoenix's special appearance. And in that response, he offered some of the evidence I've already cited, but he offered no evidence, A, that Odyssey Marine, whose contacts he wishes to impute, is a parent at all.
So if he didn't plead it, do we get to the proof?
Well, Your Honor, again, shortly, the courts do consider in a jurisdictional analysis the petition itself a plaintiff files and their response brief to the special appearance. So I guess a better way of saying that is it's fair game, although rather later than I would have preferred.
Yeah, I mean, well, I'm sorry to go over time a little bit, but that seems to be sort of an unsettled issue to me because of that Kelly versus General Interior Construction case that says it has to be the petition that makes these allegations. So I mean, I know what you're saying, but do you know, are you familiar with that Kelly case?
I have read that case, Your Honor, several times, but I will say, and Justice Bridges, if I may continue answering your question.
Absolutely.
Thank you. I will say that that was not an issue we raised in our brief because, as I read the case law as a whole in jurisdictional analysis and challenges, the court seemed inclined to look at the petition, where honestly it should have been pleaded and wasn't. But they will also let a plaintiff raise their jurisdictional arguments and their response to the special appearance, and that is indeed here where Mr. Carlton first raised the imputation of contacts, and in fact he made it his sole effort, frankly,
Let me
to
just
establish
ask you
jurisdiction.
something very briefly, and I'm piggybacking on Justice Boatman's question. Even if we adopt that analysis that to go beyond the petition, is it your position that the petition nor the answer to the plaintiff's answer to your special appearance, that they do not make the necessary finding at all to meet their burden of proof?
It is absolutely Odyssey Phoenix's position that Mr. Carlton's response to the special appearance and all of its attachments, all of it together, do not begin to approach the stringent showing necessary to impute some other entity's contacts to this appellant. That is correct, Your Honor. So, hearing no further questions, thank you.
Thank you, sir. Appellee?
Good afternoon, and may it please the court. Andrew Gould for the appellee, Howard Wilcox Carlton. The trial court properly denied Odyssey Phoenix's special appearance, and it did so in part because it properly applied jurisdictional veil-piercing principles to treat all of Odyssey's various corporate entities as one single unit. And let me jump straight into that issue and try to answer some of the questions that have come up. One of the questions was, is it a problem that we didn't plead it in our petition? The answer is no, it's not a problem. I will grant you, Justice Boatman, this court has not ruled squarely on the issue. This court's sister court, the First Court of Appeals, Justice Brown in TMX Finance, which is cited in the brief, that was one of the arguments there. The argument there from the defendant was they didn't plead it, and so we don't even get to the proof. And the court rejected that and said under Rule 128, we look to the petition as well as to the supporting papers. And so that's, we respectfully submit that that is correctly decided, and that although my friend is right, it hasn't been argued here. If this court were to go down that road, it should follow that case. But I want to take a step back. I want to discuss the substance of the veil piercing, but I also want to talk about the procedural problem that we see here. This is an unusual case in the way that it was litigated. Normally, the word in the briefs that Odyssey Phoenix said was that we, quote, lumped together all of them. Except they did. I mean, that's what makes it so strange, is that below, they constantly litigated this as if they were one single unit.
But don't you have the burden to prove alter ego or lack of corporate separateness?
Yes, with a caveat. Yes, we have the burden to prove it, and we did. We did in our response, we explained why you can treat all of them together as one. But then what happened next? At no point did they ever raise this as an issue, even at the hearing.
Do they have to raise it though? Isn't there a presumption that they are entitled to?
Respectfully, I don't believe so. Now, there is a case that they've cited, Deanda, from the Corpus Christi Court of Appeals, that suggests that. What Deanda relies upon is from the Supreme Court's opinions in PHC Minden and BMC Software that says the burden is on the plaintiff to prove this. I don't disagree with that. How could I? But we met that burden in our response, and at no point did they seek to then rebut it. What Deanda goes on to say is that, well, it's never going to shift because the burden is on the plaintiff. But neither PHC Minden nor BMC Software involved the facts here, where the defendants themselves never even raised such an argument in the first place, that, hey, by the way, it's improper for you to be treating us all together.
But Texas law presumes corporate separateness. I mean, they're strangers unless you prove they're not strangers.
They are strangers, but my point, Justice Boatman, is that once we raised it in our response, we provided the evidence, and then there was no reply. There was the hearing. It didn't come up at the hearing. The court then denies their special appearance, and then in what was titled a reply/motion for reconsideration, it was raised for the first time.
The court denied not Odyssey Phoenix's special appearance, but I mean in the hearing, I'm referring to the hearing that occurred, but the other three defendants.
So what happened was that it took it under advisement, denied the one, then denied the other. So it was just kind of in sequential order. But I guess let me just, if the court, just one final point on procedure, which is on jurisdiction. Part of why I'm harping on that it can't be right that if we meet our burden, it's never going to shift to them. Personal jurisdiction is waivable. It's not like subject matter jurisdiction, which can never be waived. I mean, that's like saying that the burden is always on the plaintiff to prove liability. Absolutely, it's always on the plaintiff to prove liability, but so they can raise unanswered defenses at some point that we have to raise them. At a certain point in time, 33.1 says if you don't timely raise the issue, the complaint, it's waived. That's the procedure.
So let's talk about whether y'all met your
Sure,
burden.
please.
What do you have?
Right, sure. So I think, so the question was, what's the law, but in terms of what do we have to show? I think we agree in terms of the basic framework, in terms of what it takes to show abnormal or atypical control. There are 4 factors. The first, the amount of subsidiary stock owned by the parent corporation. Here we have, and we presented this, that all of the companies are 100% owned by Odyssey Marine Holdings. That's in the franchise tax reports at Clerk's Record 173.
But in that, sorry to interrupt.
No, please.
So that's the, they mention that in the annual case, but then they go on to talk about control, not just stock ownership.
Correct. And I'll cede you this. If that's all we had, then this would be a very easy case for you to reverse. But that's not what we have. That's just one fact. Although what I will say is in Amneal, that I don't even think they had, I think it was a minority.
Yeah,
there was 49%. I mean, they're talking about this being very usual, that there's nothing abnormal about this, where it's one company that owns about, it's, as far as we understand from the deposition, over a dozen companies are all 100% held. But that's just the one factor. Let's move on to the other factors. The second factor, the existence of separate headquarters. There are none. They're all housed out of the same place. The third factor, observance of corporate formalities. There's no evidence in the record showing that they observed corporate formalities, and part of that comes out, I would say, in the deposition, which I'll get to in a moment. And fourth, what cases call the most important factor is the fourth, the degree of the parent's control over the general policy and administration of the subsidiary. And here we have this unusual situation which all of the companies have the same CEO and the same two-member board. And in Mr. Danton's deposition, at one point he's even testifying just as to one Odyssey. Odyssey Phoenix says that our characterization of this borders on absurdity. I would just urge the court to read it for itself. Those are his words, where he, and this is at 163 and 64, he is just talking about one Odyssey. What brings us back is to the...
Is that the evidence you are suggesting that clearly shows Odyssey Marine Holdings had absolute control over Odyssey Phoenix?
It's one factor.
What
yes.
else?
So again, it's the 100% ownership.
I meant to the control, to show absolute control. So what other evidence is there in the record to support that Odyssey Marine Holdings exerted absolute control over Odyssey Phoenix?
Just in the record, Your Honor, all we have is the deposition and Mr. Danton's testimony, where he's just generally testifying about one Odyssey. And we would say that taking the standard of review in which you have to imply all factual findings in the light most favorable to the ruling, the trial court could infer through that indeed we had through one person really exercising control over the companies. This is like the El Puerto de Liverpool case, which we cited in our brief. What that case said
So
was
what case was it?
I'm sorry, El Puerto de Liverpool. It's from the Corpus Christi Court of Appeals. It's cited in our brief, and they say piercing the corporate veil is proper when, quote, each company in the corporate family performs a separate and distinct function, yet the companies work together as an interlocking whole. And they pierce the corporate veil for purposes of jurisdiction.
So can I back up to where
Please.
the case you mentioned before this one that you
Yes.
just mentioned, you were talking about control, and you said parent controls the subsidiary. So is that what you're trying to do? Because my understanding was that Marine Holdings isn't the context that you're trying to compute.
That's true, Your Honor. So this is an unusual situation in which what we're basically saying is that all of them together should be treated just as one whole, the interlocking whole of the alternative.
Interlocking whole doesn't sound like control.
I'm sorry?
Interlocking, whatever you said. Interlocking.
Sure.
That doesn't sound like control. That sounds like,
Well, but if
know.
it's all coming from, if they're effectively one and the same, which is really what the jurisdictional veil piercing goes to, is are they all acting just as one?
and
I think
this is your best case. This is
it's one, yeah, it's one of them. The case law also uses the words, are they treated as separate offices or departments? That's another way that the courts have looked at this. And so we would say that this is how it should be treated here. And again, we're just in this unusual position where Odyssey, and I am going to talk about them all together because that's how they did below, they treated themselves you can impute them. But just to go back, if you'll go to Reporter's Record 20, that's where you'll find the quote about it's not going to be materially
I
different.
just wanted to make sure it is what I printed out. And Mr. Grennan says, and just a little bit of background, Judge, and he says, I don't think subbed in, but we added in, and so I think y'all probably agree that it materially changes the analysis one way or the other from that motion to this one. And Ms. Sanders says, I don't believe it does. Mr. Grennan says, that's what I thought. So I was correct in thinking that that's a part of the record you are relying on.
That's a part we're relying on, yes, Your Honor. I only have 25 seconds left, so I'm happy to give it back to the court unless the court has any further questions. We ask that you affirm. Thank you.
Rebuttal?
Thank you, Your Honor. I'd like to address the waiver issue first, and I'd like to put it to bed. Let me explain to the court what happened in this. There were no fact findings made. And it is true that appellate courts will apply facts where a trial court does not find them if supported by the evidence. Take your pick of cases that state that almost boilerplate standard of review language. Courts imply facts necessary to support a judgment if those implied facts are supported by evidence in the record, which, as we have said before and I urge again, is fundamentally, manifestly not the case on the stringent standard that Mr. Carlton must meet to pierce the veil and impute any other entity's contacts, let alone a corporate sibling, which, as I hear, I believe he has now conceded he has no authority to direct this court to for a horizontal style of veil piercing. But as to that, I'd also like to address the El Puerto case that was cited, albeit briefly, in Mr. Carlton's brief, and which we've heard again today. That is, I think, from 2002. It has some age on it, and it is what I would call Mr. Carlton's support for the one big happy corporate family theory of veil piercing. That is not the law. The Texas Supreme Court in 2007, I believe it was, but at any rate, subsequent to El Puerto, which is not one of this court's cases, at least as I recall, clarified that the test is quite stringent and that this corporate family, everyone working together for a common goal idea, such as in El Puerto, although that was not discussed in PHC Minden, is not endorsed by the Texas Supreme Court. So in PHC Minden, the Texas Supreme Court clarified and emphasized the demanding nature of veil piercing, and I do not think that Carlton's reliance on El Puerto reflects a reliance on the current state of the law as to what he must prove in order to impute some other company's contacts to Odyssey Phoenix. And so if there are no further questions from the court, I will cede the balance of my time.
Thank you, sir. All right, thank you. This case is submitted. So, can I have a representative from the DA's office come up? Come on. This way. We don't see your opposing counsel. Neither do I, Your Honor. So, we're gonna take a small break, just for a second. It would be the kind, not necessarily forced thing to do, to reach out to make sure that he's okay, to see if there's some sort of reason that he is not joining us. In absence of that, we'll get started shortly, okay? All right. please be seated. So, come on up. Are you ready, sir?
Yes, Your Honor.
I appreciate you reaching out to the other side. And my understanding is there was no response. I've been not signaled by anybody in our staff that there was something that came up. So with that, I would normally ask you at this time if you want to reserve some time for rebuttal, but that doesn't seem appropriate now. Begin.
May it please the court.
Yes.
Good afternoon. My name is Joseph Sanchez. I'm a prosecutor with the Harris County District Attorney's Office, and I represent the appellant in this matter, the state of Texas. This is an appeal from an order granting habeas relief without adequate showing of prejudice. In this case, the defendant filed a writ application under Article 11072 of the Code of Criminal Procedure while serving a 3-year deferred adjudication for retaliation. In his writ application, the defendant alleged that his plea attorney, Mr. Phil Green, rendered ineffective assistance of counsel and thus rendered his plea involuntary by failing to advise him of the immigration consequences of his plea.
And you agree with that?
I believe that this record would support a finding of deficiency when it comes to ineffective assistance of counsel. Yes, ma'am. Yes, Your Honor. And Mr. Green did submit an affidavit at the habeas court's order. The habeas court held a hearing at which Mr. Green was the only witness to testify, and then the parties submitted proposed findings, and the habeas court granted habeas relief by adopting the applicant's proposed findings in total. And one of those findings specifically found that Mr. Green knew that the applicant intended to use a prospective marriage as a pathway to residency, and that he was harmed, that the applicant was harmed.
Were they engaged at the time?
There is no evidence of that in the record, Judge. And that is specifically part of the issue, is that there is no evidence to support this prejudice finding, and therefore it was an abuse of discretion by the habeas court to find prejudice.
But even if they got married, a deferred adjudication on a felony is considered a final conviction for immigration purposes.
Yes, Your Honor.
And so it didn't matter whether or not he was going to marry, I'm assuming she was a U.S. citizen and he wanted to obtain a lawful permanent residency, but that deferred adjudication, which Mr. Philip Green, and I quote, he would be unconvicted, his record expunged, and he would have no record. That's not true.
Yes, Your Honor, that is legally inaccurate. However, in order to achieve habeas relief, this defendant needed to both plead and prove 2 sub-elements of prejudice, which is specifically that he would not have pled guilty and he would have insisted on a trial. And therein lies the issue, is that there are no pleadings and there's no proof that he would have insisted on a trial.
I do have one question on that. So the Aguilar case, which I'm sure you're familiar with.
Yes, ma'am. Yes, Your Honor.
I've got this paragraph here, and there's, they're quoting what, Aguilar says, I would never have agreed and entered a guilty plea, blah, blah, blah. So all he says is, I wouldn't have entered a guilty plea. And then at the end of the paragraph, they say, Aguilar has demonstrated that, but for the error, he would not have pleaded guilty and would have insisted on a trial. So they really take it to mean that if you say you wouldn't have pleaded guilty, then you are insisting on a trial.
Well, there is case law from the Court of Criminal Appeals that actually speaks to the exact opposite of that. So one of the cases that I quoted was Ex parte Torres. And in Torres, Mr. Torres stated in his habeas proceedings that he would not have pled guilty. And then when it came to what he would have done instead, he said he would have either sought an immigration neutral plea, he would have delayed his plea of guilt in order to seek some sort of relief in immigration court, or in the alternative, he would have sought a trial. And the Court of Criminal Appeals indicated that that was an insufficient showing that he would have insisted on trial, and therefore he had
But
failed
he
to show
gave
prejudice.
3 options.
Yes, Your Honor.
Whereas our defendant
Did not.
did
give any.
not.
And that's why I think, so I did in my brief cite to Ex parte Nelson. It is also from the Court of Criminal Appeals. It's unpublished, so it doesn't really hold any water. However, I cited to it because I think factually it's closer to what we have before us, which is just our defendant here says that he would not have pled guilty, but is silent with regard to what he would have done otherwise. And when you combine that with the Court of Criminal Appeals analysis in Torres, and then another unpublished case from this court called Odelugo, I think what you can glean is that no one can really tell us what the defendant would have done other than plead guilty, other than the defendant themselves.
Doesn't I'm sorry. Go
Oh,
ahead.
so in all those cases, talk to me about where they were procedurally. Were those from grants of relief on those writs or denials of relief? Because it makes a difference in the kind of deference we give to the findings or the implicit findings when there are kind of holes.
So in the Torres case, that was an 11072 that was denied, and the Court of Appeals reversed that denial, and then the Court of Criminal Appeals reversed the Court of Appeals. In the Nelson case, the Court of Criminal Appeals, that was also an 11072, the Court of Criminal Appeals granted relief in that case, and the Court of Appeals reversed, and the Court of Criminal Appeals affirmed the Court of Appeals.
The trial
reversal.
court granted
Yes, Your Honor.
habeas in that one. So
Yes.
the first one, the trial court denied it, the second one, so
Yes.
you have some cases both ways.
Both ways.
Doesn't the
and-
applicant testify in his affidavit regarding what he would have done had he been admonished about his immigration consequences?
No, Your Honor. So in his affidavit, well, I will give you a timeline to help you. So this applicant was indicted in November of 2021, and then Mr. Green signed on in February of 2022, and then in July of 2022, this applicant pled guilty, and then in August of 2023, he got married, and then in October of 2023, he executed the affidavit that is an exhibit to his writ application. And in his writ application, or in his affidavit, excuse me, he says that he would not have pled guilty, period, full stop. He does say, I intend, and he uses the present tense of the word intend, to use my marriage as a pathway to residency. However, on the face of it, his affidavit was signed over a year after his plea. So then the question becomes, was Mr. Green aware of that intent at the time of his representation? Because a writ applicant in this situation, in a Padilla situation where they pled involuntary plea, when it comes to their insistence on trial, they can either explicitly say, I would not have pled guilty, or I would have insisted on a trial, or they can say, I would not have pled guilty, and then they can prove up additional circumstances from which the habeas court could infer they would have insisted on a trial. And we don't have either in this case. And so without either, there can be no proper showing of prejudice, meaning there can be no ineffective assistance of counsel.
So what do we do with Mr. Green's testimony that his primary, well, it's a little bit unclear, yeah, as is the record in this case.
Yes, Your Honor. So Mr. Green's testimony is a little unclear.
Yeah, but I mean, so if we read it as saying that the defendant's primary concern was trying to avoid prison time, how does that work? You know, how do we balance the evidence in a case like this?
Sure. So I think the first thing is I will kind of address the elephant in the room, which is that in this record, there is a marriage license and there is a marriage certificate. It appears in the record attached to the plea papers, which the applicant attached as an exhibit. Normally, people's marriage licenses and certificates are not made part of their plea packets, so I think he intended for those two documents to be considered. However, when you look at the face of those documents, the marriage license was issued by the Harris County Clerk's Office on August 12th of 2023, and the return was filed by the officiant on August 18th of 2023. And what the Family Code tells us about marriage licenses is that they expire within 90 days. And so either that marriage license was issued on August 11th of 2023 or as late as May of 2023. Regardless, all of that post-dated his plea by a year. And so I say all of that to answer your question, which is when Mr. Green says that his primary concern was not immigration consequences, then it makes his claim now in post-conviction, quite frankly, not credible and not existent.
But isn't that the trial, we defer to the trial court on credibility.
Correct.
So, I mean, are we weighing Mr. Green's testimony against the affidavit, or is Mr. Green's testimony just totally?
I don't think that it's you're weighing Mr. Green's testimony against any of the evidence, because I think the bigger issue is that the issue isn't that there is insufficient evidence, the issue is that there's no evidence that he would have insisted on a trial. And there's no evidence from which the habeas court could have made the inference that he would have insisted on a trial. So I think, if anything, Mr. Green's testimony that his primary concern was avoiding the least aggressive form of punishment corroborates that the trial court had nothing from which to infer that he would have insisted on a trial. Or at least it corroborates the notion that, quite frankly, he wouldn't have insisted on a trial. Because either I quite frankly don't know whether the applicant drafted his own affidavit or if his habeas attorney did it for him, but the fact that whether he would have insisted on a trial or not is not in that affidavit for one of two reasons, either because he actually would not have insisted on a trial and he couldn't swear to that, or whoever drafted it just left it out, but the fact remains that it's not in this evidence, it's not in the record.
So, in your opinion, when they wrote Padilla, they talked about the fact that some people are more afraid of being deported than they are of going to prison.
Yes, sir.
As far as we can tell, the applicant in this matter is still here in the country, correct?
I do not know what his current status is, but I can tell you that in this case, he doesn't claim that he is in deportation proceedings. The immigration consequences that he complains about in this case is that he cannot achieve permanent residency through his marriage.
Yes. So, is there some case that I glossed over in the briefing on this that says that kind of collateral consequence isn't really the kind we're intending to cover in Padilla?
Not that I'm aware of, Your Honor, but what I will tell you is that in the briefing there is a case that talks about how reviewing courts cannot and should not overturn pleas in Padilla cases based on post hoc assertions by defendants on what they would have preferred, and instead you need to look towards the record for contemporaneous evidence about what they would have preferred at the time of their plea. And what we know from this record is that at the time of the plea, regardless of what Mr. Green told him, the trial court itself warned him, both in writing and, quite frankly, very likely verbally, even though there's no record of it, that his plea did have immigration consequences. And so he was aware of them, and he didn't stop the plea. And then in addition to that, as I stated earlier, there's no evidence that at the time of his plea that he made Mr. Green aware that he was dating his wife, his now wife, that they were engaged. And within these writ proceedings, it's the applicant who bears the burden, right? So it would have been quite easy for him to prove that up if it were true. I mean, his wife could have submitted an affidavit, she could have come to testify, but none of that happened. And so I don't think that, to answer your question, I'm unaware of any case that says that this is the type of immigration consequence that was envisioned by Padilla, but what I do know is that the evidence from this record doesn't support any inference that he was prejudiced.
So you were just saying that his wife could have testified, but that would all have been post hoc as well, right? What
Certainly.
kind of evidence? Do the cases usually rely on evidence that was actually at the time, or do some cases rely on evidence later about what, you know what I'm saying?
Yes, ma'am. Yes, Your Honor. So when cases do rely on evidence that is post hoc, so evidence in the form of testimony at an evidentiary hearing or an affidavit, usually there is some level of credibility assigned to that by the reviewing judge. However, that evidence still has to exist before the judge can assign any credibility to it. So the best example I can give you, and it's actually a published dissent by the CCA, and it's a case called Ex parte Mukimian from 2023. The CCA granted relief in that case. However, Mr. Mukimian was a native of Iran. He had achieved some form of asylum here in the United States, was convicted of a felony pursuant to, I believe, 1244A, and then filed an 1107 writ alleging Padilla-type claims, and the CCA granted him habeas relief. But in his affidavit, one, he stated that he would not have pled guilty and would have insisted on a trial, and then two, in his affidavit, he swore to the facts that he was from Iran, that he left Iran to escape persecution, that going back to Iran meant almost certain death for him, and that deportation to Iran was avoidable at all costs. Now, the majority granted habeas relief in that case. However, it was a published dissent. And so in the dissent, there were some CCA justices that stated that Mr. Mukimian would have known about those potential consequences, or at least would have known that, going back to Iran, he could have faced death. And then at the time of his plea, he was warned about the deportation consequences, but he still went through with it. And so the dissent talks about how they would have remanded the 1107 writ so that the credibility of his claim that he would have insisted on a trial could be tested. But my point is that at least Mr. Mukimian stated post hoc in his affidavit that he would have insisted on a trial, and we simply don't have that here. So I see my time is almost up. If there are no further questions, I will cede that time back to the court, and we just ask that you reverse the habeas court and deny habeas relief. Thank you.
All right. Case is submitted. Thank you, sir.
No,